Hi, this is Dr. Victoria Nalule, and we're continuing with our webinar series on international arbitration in the African energy and mining sectors. So this is a book project. It's a live book project, and we're expecting over 50 chapters from different experts across Africa and other continents. So the book is edited by Dr. Victoria Nalule, that's me, and Professor Damilola Olaweye. And we're hosting a series of webinars for the book chapters. And in today's webinar, we're going to be having Dr. Franca and Miss Afia, both from Ghana, and their book chapter is on dispute resolution in Ghana's energy sector. So without wasting any more time, I would like our speakers to briefly introduce themselves, and then afterwards, they'll give us a brief background about their book chapter. What do they cover in this book? And also we shall have the concluding remarks. So this is going to be a short webinar, but remember to look out for this book chapter once it's published next year. Franca, would you like to introduce yourself?
Thank you very much, Dr. Victoria, and thank you so much for inviting us to join in the contribution of the book. As Dr. Victoria said, my name is Francisca, full name is Francisca Kusiapia. I'm the acting head of department for Public Law Department for University of Professional Studies Law School. I lecture some areas, including natural resources, energy, contracts, competition law, and my areas of research focuses also on energy, natural resources, competition, arbitration, and sustainable development. That's all. Thank you.
All right. Thank you very much, Dr. Franca. Ms. Afia, would you like to introduce yourself?
Thank you very much, Dr. Victoria. My name is Afia Achumanam Fonsamenta. I'm also a lecturer at the UPSA Law School, and I teach courses such as energy law and commercial law. And my areas of interest border on energy law, regulation, and other aspects of regulation. Yes. So I am very pleased to be here too. Thank you very much.
All right. Thank you very much for the brief introduction. So I think we can start with our discussion with respect to disputes resolution in Ghana's energy sector. What should we expect to see in your book chapter, and what are the key concerns when it comes to dispute resolution in the energy sector of Ghana?
Thank you. If you could project.
Yes, please. I'd like to just share my slides. Yes, please, is it visible?
Yes. Yes. Okay. So our book chapter, which is a contribution to the book project by Dr. Victoria, is entitled Dispute Resolution in Ghana's Energy Sector. And the authors are myself and Ms. Afia. Since we are going to have a very short discussion, we will focus on the salient areas that our book chapter touches on. So to give you an idea, Ms. Afia will take us through the salient areas covered.
Yes, thank you very much, Dr. Francisca. Our chapter looks at an overview of Ghana's energy sector, looking at the subsectors, namely petroleum, renewable, nuclear, and electricity, and also looking at the various statutory provisions related to dispute resolution. We'll also go ahead to look at the regional energy dispute obligations, and then give our conclusion and recommendations that we have in our chapter.
So as indicated, our chapter gives a brief overview of the Ghana's energy sector, which is a bubbly one. It's made up of the petroleum, nuclear, renewable electricity sectors, but it's often dominated by the petroleum and electricity sectors. The nuclear and renewable sectors are quite new, and particularly the nuclear. And now we move on to the specifications or addressing the various provisions under the subsectors.
Well, looking at the petroleum subsector, we have both the upstream and the downstream sectors. Now, in the upstream sector, activities that go on there include exploration all the way to extraction. And in these activities usually are done either onshore or offshore. In Ghana, however, most of these activities are done offshore. And you will see that in Ghana, there's usually a lot of contracts between the host nation, that is Ghana, and other energy investors. So Ghana has what we call the Petroleum Model Agreement, which forms a foundation for all upstream and petroleum negotiations and contracts.
And due to the constant involvement of international energy investors to support the local energy investors, there's bound to be disputes. So the Petroleum Model Agreement gives a basis for dispute resolution in terms of contractual agreements. And anytime there's a dispute between an investor and the states, the first step is to start with consultation, as our book chapter indicates, and then you move on to negotiations. Now, if negotiations fail, then you can move on to arbitration. Again, alternatively, as our chapter also discusses, sometimes the parties to the agreement may have selected a sole expert to resolve the disputes within 90 days, but failure to do so, then they have the option of also moving on to international arbitration to resolve it.
Now that we've looked at the contractual aspect of it, there are also statutory provisions to that effect. So under the upstream sector, we have the Petroleum Commission, which serves as the regulatory body in that sector. And it was established under the Petroleum Commission Act of 2011. Now, when it comes to grievances or complaints, the person who is aggrieved by a decision of the Petroleum Commission can lodge a complaint in writing to the Minister of Energy within 30 days of having received that decision from the Petroleum Commission. Now, when the Minister of Energy receives this complaint, he also has 30 days to make a decision. If the 30-day period lapses without any decision from the Minister of Energy, or in the event where the aggrieved party is not satisfied with the decision of the Minister of Energy, that person has the avenue to apply to the Ghanaian courts for a review of that decision as well.
Now, the book also looks at the downstream aspects of the petroleum subsector of the energy industry.
Under the downstream sector, we have the National Petroleum Authority. This is the regulatory body that governs the downstream sector. And the activities that go on in the downstream sector range from import to exportation of petroleum products, sale and marketing, distribution, shipment, what have you. Now, where there is a grievance in the downstream sector, we have what we call the Complaint Settlement Committee, where a written or oral complaint can be made to them. Now, when the committee receives a complaint, that committee has 30 days within which to make a decision. Where a decision has not been made within the 30 days or the aggrieved party is not satisfied, then the aggrieved party moves on to the National Petroleum Authority Board for investigation. And now the board has 14 days to make appropriate determinations with reasons. Now, this process applies mainly to consumers, but not to petroleum service providers.
For the petroleum service providers, anytime there's a dispute among them, they are required to negotiate in good faith, as discussed by our book chapter. Now, where unfortunately they are not able to resolve the issue amicably, then the National Petroleum Authority Board would set up a panel under the Alternative Disputes Resolution Act of 2010, Act 798, to arbitrate and settle the dispute. Now, this is in brief what our book chapter discusses for petroleum. But then we move on to the other subsectors. We start again with the renewable.
Renewable energy is, as Dr. Francisca said in the beginning, fairly new in Ghana's energy sector. So they have the Renewable Energy Act was passed by Parliament in 2011. And where there are grievances between the licensee and the Energy Commission, it happens in cases where the person or the licensee applying for a license or a renewal has been refused, or his license has been modified, suspended, or cancelled, usually by the board of the Energy Commission. In this event, the licensee or the person who applied for the license may lodge a complaint to the Minister of Energy within 30 days of having received that decision of the cancellation or suspension of his license. Now, when the Minister of Energy receives the complaint, he has 30 days as well to investigate and make a decision. Or he may choose to set up an arbitration panel under the Alternative Disputes Resolution Act to settle the matter amicably between the aggrieved parties. Now, in the instance where the minister and the aggrieved person or party are not able to reach an amicable solution or settlement, or where the minister has failed to make a decision, the aggrieved person has within 14 days to apply to the High Court for a decision in the matter or a review.
Now, this portion of our book chapter looks first, looks first at the dispute between the licensee and the Energy Commission. On the other hand, if there's a dispute between licensees, what happens? Often than not, the board of the Energy Commission, either on its own or at the request of a licensed person, shall set up an arbitration panel under the Alternative Dispute Resolution Act to resolve any dispute among these licensed parties. You are urged to read our book to find more, but moving on to nuclear subsector. The nuclear subsector, as I already indicated, is fairly new, and it actually looks at radioactive materials. But these radioactive materials have hardly been used to generate electricity.
Under the nuclear subsector, the regulatory body here is the Nuclear Regulatory Authority that was established under the Nuclear Regulatory Authority Act of 2015. Now, the aim of this act is to regulate and manage activities and practices for the peaceful use of nuclear material or energy, so for electricity and all of that. Where there's a grievance under the Nuclear Regulatory Authority Act, the person who is aggrieved by a decision of the NRA board may submit a complaint to the minister. This complaint, of course, has to be in writing, and he has to submit it within 30 days of having received that decision of the board. Now, when he is submitting his complaint, he must specify in the complaint the issues objected to, and also attach a copy of the decision by the board and any other relevant documentation that may help in the determination of his case. Now, when the minister receives this complaint, he will also refer the complaint to what we call the complaints panel, which of course will give a fair hearing to all the parties concerned. Now, after the hearing of the parties, the complaints panel gives its recommendations to the minister. And the minister, these recommendations are to be given within 60 days. Now, when the minister receives them, he can either accept or reject the recommendation of the panel and proceed to take a decision which must be in the interest of the nation, and shall also give reasons as to why he made such decisions. where the aggrieved party is not satisfied with the decision made by the minister, he can also appeal to the High Courts for a review of the decision. And this decision has to be, these proceedings, of course, will be held in camera. Now, where there is a claim for compensation for nuclear damage which has been caused by a nuclear incident, either within the country or within the country's exclusive economic zone, these claims, the claim shall lie in the High Courts, meaning the person has to go to the High Courts for a decision to be made. And these proceedings, of course, are held in camera because of the sensitive nature of the incident.
Now we move on to the electricity sector. With the electricity sector, it covers the generation, transmission, distribution, and supply of electricity, and mainly is dominated by thermal power plants, hydro, and a smaller portion contributed from renewables as well. Now, the energy sector is regulated by the Energy Commission. The Energy Commission is responsible for granting licenses. So anytime the Energy Commission makes a decision either to suspend or to cancel a license, anyone who is aggrieved can lodge a complaint with the minister within 30 days of receiving that notice. Now, the minister is obligated to give his decision also within 30 days. Failure to do so, or if the minister gives a decision which is not satisfactory to the complainant has every right to proceed to the court for resolution. And we can see here, we have some cases as discussed in our book chapter, the Attorney General versus Balkan, Esibe Yeboah versus Electricity Company of Ghana, all discussing power purchasing agreements. The basis of these two cases, the issue which was sent to court was to determine whether the power purchasing agreement were international transactions under Article 181 of our 1992 Constitution. Now, our chapter discusses in detail these cases, but the conclusion drawn is that, yes, statutory provision under the Energy Commission Act gives room for parties to proceed to court to resolve their disputes. However, since the statutory provisions makes no room for international arbitration, practice also makes provision for that. And you can see that in the GBGC Limited versus the government of the Republic of Ghana. Now, in the first two cases, AG versus Balkan and Esibe Yeboah cases, our book chapter discusses extensively the issue that where, especially in the Balkan case, where the parties have agreed to an international arbitration, they would not be stopped from proceeding to arbitration based on a statutory provision. On the other hand, the GBGC Limited versus the government of the Republic of Ghana extensively discusses the option of using international arbitration to resolve power purchasing agreements. And in that case, although the issue before the tribunal was that the termination of the energy contract was unfairly done, at least the case in question points to the fact that even if there are no statutory provisions, at least they can proceed through international arbitration, through practice. That is looking at dispute between the licensee and the commission. What about disputes between the licensees themselves? Our book chapter goes ahead to discuss that at any point in time, and when there's a dispute between the licensees, they may proceed to seek assistance from the board of the Energy Commission, who would seek to resolve it through alternative dispute resolution, with the final step being arbitration panel set up if all those initial alternative dispute resolution mechanisms fail. Under the electricity subsector, there has also been some introduction of some new laws which have added on to or made provision for dispute resolution, and our book chapter extensively discusses that. The first one is the Energy Commission Local Content and Local Participation Regulations of 2017, which seeks to give more opportunities to Ghanaians, especially in the electricity sector. Anytime the Energy Commission makes a decision under the regulation and anyone is dissatisfied, you may, just like the previous provisions, you may lodge a complaint within 30 days of that decision. And the Energy Minister is also responsible for giving a decision within 30 days, failure to which the party may proceed to the courts. The other regulator, apart from the Energy Commission, under the electricity sector is the Public Utilities Regulatory Commission, PURC. Now, they are responsible for regulating the tariffs in the electricity sector. So often than not, they receive complaints from both the consumer and the public utility. The public utility here being the supplier, generator, or transmitter of electricity. So we may have a complaint by the public utility against the consumer, or the consumer complaining against the public utility, which is the often situation that we have. And then, or we may have a public utility also complaining against another public utility, or a consumer lodging a complaint against another consumer. So basically, when you lodge a complaint, they have to go through the service procedure, serve notice onto the respondent, 5 days to respond, and then the investigation starts. But there's a step procedure, so they start with mediation, and then they move on to formal hearing. If that's, sometimes they may require, during the formal hearing, they may require some expert assistance, and so they seek expertise and the experts' opinions on that. Again, we have the recently passed Public Utility Regulatory Commission Consumer Service Regulations, which seeks to encapsulate all the other provisions. It's fairly new, so I must confess that you do need to read our chapter because it's not been extensively discussed in Ghana, and we may be the very first to extensively discuss it. So under the LI 2413, the consumer services committees are required to be set up to help resolve all consumer complaints, and public utilities are also obligated to come out with their customer charters. And these customer charters are to provide consumers with procedures as to how they will lodge their complaints. And these, all public utilities cannot change the customer charter without the permission of PEC. Now, anytime there's a complaint I'm giving examples as discussed by our book chapter about specific complaints, a complaint by a public utility against another public utility, as often happens on the grid. They first start with negotiation, move to mediation. If that fails, then the Energy Commission will set up an arbitration panel. Our book chapter also discusses extensively that when a consumer lodges a complaint against a public utility, that public utility has no right to disconnect the service to that consumer until the dispute is resolved. The case of Hansnam Enterprises versus Electricity Corporation of Ghana, 1992, although it was discussed before the establishment of the regulators, it seeks to establish the fact that there's a duty of care of all public utility regulators, utilities, meaning if you're a supplier of electricity, you owe a duty. And in this particular case, there were fluctuating supply of electricity, which caused the destruction of electrical gadgets. And unfortunately, the complainant did not win the case because of lack of evidence. But the court clearly indicated that had there been evidence, they would have held the public utility liable. So this case confirms, as in our book chapter, it confirms the fact that there is a duty of care by all public utilities. Now we move on to the regional level. Ghana is part of the ECOWAS sub-region. And so having signed some numerous international agreements, Ghana also owes some obligation on the regional level. And our book chapter discusses it under three main areas. The first is the ECOWAS Energy Protocol of 2003. Under that protocol, anytime there's a dispute between an energy investor and a member country, they are required to settle it amicably. However, if they are not able to do so, the energy investor is free to proceed to the courts or administrative tribunals of the contracting party to resolve it. Alternatively, as often happens, the parties may also resort to international arbitration, especially if they've made provision for it in their agreement. And the ECOWAS Energy Protocol supports resolutions through ICSID, also through the Stockholm Chamber of Commerce and OHADA. The second international agreement we discussed in our book at the ECOWAS level is the ECOWAS Articles of Agreement of the West African Power Pool Organization, WAP, and it functions 2005. As a member of ECOWAS, anytime there's a dispute between any of the members, including Ghana and any other country, we have to begin by requesting dispute resolution through the Secretary General. And at that point, a three-member panel will be established. And after the establishment, they often start with advisory proceedings, and they move on to mediation, and then non-binding dispute resolution, and finally to a binding dispute resolution, which will be final. The last international or a regional agreement we discussed in our book chapter is the ERERA, or ECOWAS Regional Electricity Regulatory Authority Rules of Practice and Procedure in 2017. Having established the ECOWAS regional electricity market, the regulator, which is ERERA, has some duties. So anytime there's a dispute among countries, at that point in time, the parties have to report to ERERA, and a hearing officer will be selected. The hearing officer would help identify the relevant issues in dispute, and then the matter will be resolved by ERERA. After the decision by ERERA, as our book chapter discusses, if the parties are dissatisfied, they will proceed to, or they can proceed to the ECOWAS Court of Justice. Now, in our conclusion,
when we did this research, we noticed that on the contract side of things, the alternative dispute resolution is what is preferred, but arbitration is really the preferred means of dispute resolution. You see, for example, under the petroleum sector, the petroleum model agreements, the model petroleum agreement, makes room for consultation and negotiation and also arbitration. But when we come to the statute law, when we come to the regulatory provisions, there are two main forms of resolving conflict. That is the alternative dispute resolution, which includes either negotiation, mediation, or arbitration, and the court system, which has litigation. For example, when it comes to issues like a nuclear incident which has occurred in Ghana because of its sensitive nature.
Now, the regional level also promotes alternative dispute resolution. And as much as possible, because of issues to do with sovereignty, no one really wants to subject themselves to each other's courts to be decided on in terms of disputes between the countries. When it comes to disputes between the investor and the countries, often than not, sometimes they also resort to court, although the preferred approach is the ADR. So in conclusion, we recommend that, especially on the national level, if it's possible, disputes resolution committees be set up at all districts or within all districts, especially if you are to promote the protection of consumers under the electricity subsector. So thank you very much for joining us. This, in summary, is what our book chapter is about. Kindly do purchase it when the moment is available to have an extensive or comprehensive details of what has been discussed here. Thank you so much.
All right, thank you very much, Dr. Franca, and thank you very much, Ms. Afia, for the brilliant presentation. Could you please stop sharing your screen? All right, so I see we have 2 attendees. Do we have any questions from the participants? As we're waiting for the questions, I would just ask you, with respect to your recommendation or conclusion, when it comes to arbitration, especially energy arbitration on the African continent, we see that in most cases, the parties to the arbitration always prefer to maybe get an external arbitrator or someone who's non-African. And I'm sure you all know some of the initiatives that have been taken to ensure that also Africans take part in this arbitration. So in this regard, what would your recommendations be with respect to ensuring that more people from Ghana take part in this arbitration, especially energy arbitration? So what would your recommendation be in that respect? And for the attendees, if you have any questions, please do write your question down. If not, then we shall just address this question and we shall have our conclusion.
Thank you very much, Dr. Victoria. I think the whole problem starts with some of the draft agreements that we have. In fact, our chapter discusses the fact that when you look at the contractual model petroleum agreements that we have, it actually stipulates that no member party should form part of the panel for arbitration. Unfortunately, that is what it stipulates. Unfortunately, that is for international arbitration. But where we can explore, I think we can explore will be most of the national arbitration, which is promoted through the Alternative Dispute Resolution Act. Because when you look at the various subsectors, apart from the upstream, which is more often associated with international arbitration, the downstream of petroleum is often connected to dispute resolution at the national level. And again, the nuclear as well as the electricity and the renewable, most of the disputes per the statutory provisions are supposed to be resolved through alternative dispute resolution mechanism through our act. And our act has set up a center. So the center promotes, or should I say local content, or should I say Ghanaians or arbitrators who can help resolve energy disputes in Ghana. So our only offsets will be the international arbitration because of sometimes distrust among the parties. They prefer not to select member parties being part of the panel on the international level, only with respect to upstream petroleum, this arbitration. But when it comes to all other arbitrations, yes, I would say extensively, there are a lot of statutory provisions to promote the participation of Ghanaian arbitrators.
All right. Okay, thank you very much for that. I see we don't have any questions from the participants, but moving forward, what would be your recommendation, or what are your concluding remarks with respect to ensuring that dispute resolution in Ghana's energy sector is advanced, or in filling some of the gaps, the weaknesses that are there at the moment? What would be your concluding remarks? I can hear from you, Dr. Franca, and also get the concluding remarks from Afia, and then this will be the end of the webinar.
Okay, all right. Okay, I'll start off by saying that from our book chapter and then our research, we realized that there's a depth of cases to support most of the statutory provision, meaning there's a lot of dispute resolution going on in the energy sector, but we don't report them. So for me, what would really promote energy dispute resolution in Ghana is to promote recording, especially when you look at the portion which says that the minister plays a role or quasi-judicial bodies play a role. We need to record them to promote transparency and predictability when it comes to energy dispute resolution, especially in Ghana. So in brief, that is what I'll say. I'll pass it on to
Thank you very much, Dr. Francisca. I would say that apart from record keeping and allowing for transparency, one thing that we can also do is to increase education. We can also talk more about the importance of alternative dispute resolution when it comes to the energy sector, educating the public, as well as even educating those who will be arbitrators, so that they are armed with the information to resolve these conflicts amicably and to also help in the energy sector moving forward. So public education and also education of arbitrators will help in advancing dispute resolution in the energy sector in Ghana. Thank you.
All right, thank you very much, Dr. Franca. This marks the end of our webinar. We are live on YouTube. For our participants, remember to subscribe to my YouTube channel, Dr. Victoria Nalule. And in this month and next month, we're expecting to host over 50 webinars focused on international arbitration in the African energy and mining sector. A book project, it's a live book project that is being edited by Dr. Victoria Nalule, that's me, and Professor Damilola Olaoye. So thank you very much. Do not forget to subscribe, and obviously look out for this book chapter, which is authored by Dr. Franca and Miss Afia. I think it's the only one, it's the only book chapter we have on Ghana. So definitely this should be a very interesting aspect to the book, but also to the audience. Thank you very much, and do not forget to subscribe. Bye-bye.